5 seconds to go. Start. PW3 stated in categorical terms that the behavior of the appellant was normal during his said stay and he was never given any medicine for mental illness because neither any mental illness was observed in him nor his family members gave us any previous history of his suffering from any mental illness. In his cross examination, this witness further removed any doubt in regard to the mental status of the appellant while maintaining that the appellant was mentally fit and sound during his stay at our center and he was admitted only for de-addiction of his habit of consuming liquor. Hence, the appellant's had only been a case of addiction to alcohol. The manager PW3 of course suggested the opinion that the appellant ought to have undergone the course for a period of 7 to 9 months and that the family members got him discharged against advice, but this statement cannot be read to mean that the appellant was to be treated as a person of unsound mind. In fact, the appellant remained admitted to the rehabilitation center from 20th November 2008 to 29th April 2009, that is, for a period of over 5 months, and as noticed above, he was never found suffering from any mental illness so as to be regarded as a person of unsound mind. It is also noticed that the plea of unsoundness of mind and therefore the benefit of Section 84 IPC was never taken in the trial nor any evidence was led in this regard. Significantly, not even a remote suggestion was made to any witness examined for the prosecution about the alleged mental incapacity of the appellant. In his examination under Section 313 CRPC, the response of the appellant is to the questions relating to his admission to the rehabilitation center, and the related facts had been that those aspects were a matter of record. In the given set of facts and circumstances, we are unable to find anything on record for which the benefit of Section 84 IPC could even be remotely extended to the appellant. Similarly, the submissions that when the state of mind, mental condition of appellant was brought on record, the trial court ought to have ordered an evaluation to rule out any doubt remain rather bereft of logic. In the relied upon passage in the decision of Gujarat High Court cited on behalf of the appellant in case of Manju Ben Supra, the court had explained the basics relating to the operation of Section 329 CRPC and its distinction from Section 84 IPC in following terms. Section 329 of the CRPC, on the other hand, provides for a procedure in case of a person of unsound mind tried before the court. Section makes it clear that in a trial before the magistrate or court of sessions, if the accused appears to be of unsound mind and consequently incapable of making his defense, then the court shall, in the first instance, try the fact of such unsoundness of mind and incapacity, and if satisfied in this regard, shall record a finding to that effect and shall postpone the further proceedings. This section is similar to Section 328 of the CRPC with this difference that the latter relates to an inquiry before a magistrate while this section relates to the trial before the magistrate or court of sessions. However, both the sections relate to unsoundness of mind at the time of inquiry or trial that the accused is of unsound mind. A magistrate cannot act on his own opinion. He must have before him a statement of medical officer who must be examined. Where the court decides that the accused is of unsound mind and consequently incapable of making his defense, the trial is to be postponed. As provided in Section 330 of the CRPC, such a person may be released on sufficient security being given that he shall be properly taken care of and shall be prevented from doing injury to himself or to any other person or for his appearance when required before the magistrate or the court. The court or the magistrate is also entitled to direct the accused to be detained in safe custody in such a place and manner as it may think fit if it is of the view that the bail should not be taken or sufficient security is not given. Section 331 of the CRPC thereafter talks of resumption of inquiry or trial when the concerned persons ceases to be of unsound mind. Section 332 of the CRPC prescribes a procedure to proceed with the trial or inquiry as the case may be. The aforesaid expositions on the scope of the provisions relating to accused person of unsound mind are not of much debate. However, nothing of the aforesaid principles could apply to the present case, for there had been no material on record and no other reason appeared during trial for which the trial court would have been obliged to take recourse of the procedure contemplated by section 329 CRPC. Similarly, the suggestions about defect in trial or failure on the part of the investigating agency to get the appellant examined through psychiatrist with reference to the decision of the Bombay High Court in case of Ajay Ram Pandit Supra remain too far stretched. In the said case, it was noticed that the investigating officer became aware of the fact after apprehending the accused that he was mentally unstable, and in fact the people in his locality used to consider him as a madman. The fact situation of the present case is entirely different. Stop.